Good morning, everyone. This morning, I want to speak about overview kind of data protection practices, what is in some data protection laws across 20 African countries. This presentation is an adaptation of an earlier work on assessment on enforcement of data protection laws in Africa. Okay, why Africa? I know many people know Africa, even though it's described on the map as a very small continent, but interestingly, it's even the landmass of Africa, it's bigger than most large part of Asia, even and North American combined. If you look at the square kilometer, it's the second largest population in the world. A lot of youthful population, internet use, projected 1.1 billion internet users by 2029, with most of them using mobile data. And also, there's kind of a growing data protection laws in the last couple of years, especially from 2020 till now. Having as of January, 44 countries have different data protection laws. Also, the continent is also battling the issue of digital colonialism and also a trending issue of data sovereignty, why African countries want to control who have access to their data. This makes us to mind, what should we look out for when we're looking for some of those enforcement patterns in some of those data protection laws that is coming from Africa? Of course, there have been an enforcement bite from Africa, some of them even targeting big tech, mostly domiciled in the US. One of the great examples is two summers ago, 2024 summer, Nigeria fined Meta about $220 million just for data practices issues, violation of data protection laws, and a lot of anti-competition issues. Similarly, Kenya also, WorldCoin also faces its own battle with Kenyan authority about deletion of biometric data of their citizens. So even locally, African countries are also enforcing against even their own government. For example, South African Information Regulator is trying to enforce data privacy violations against their own Department of Justice. That shows that it can be turning into intriguing issues across Africa. And that's why we need to be concerned when we are dealing with data coming from this part of the world. What are my research questions? My research questions focus on what are the enforcement mechanisms or trends from the continent, who is responsible for enforcement, and what kind of sanctions and some of those laws prescribe, and how it's going to affect every one of us working as privacy professionals. Before I go further, I just want to give a brief discussion about privacy as a foreign concept in Africa. What is the notion of privacy in Africa? There's kind of an earlier argument that privacy is about foreign in Africa. It does not peculiar to Africa. It's more or less of a Western or European influence that influenced privacy in Africa. Of course, colonial legacy affects a lot of legal laws and regulations in Africa because, for example, most African countries either adopt a common law approach using the British system or a civil law approach using the French system. And of course, the Brazil effect has its own effect on Africa. However, some schools of thought argue that privacy, looking at historical state of African cultural beliefs, privacy of their own family, especially more from a communal, collective approach, there is privacy indigenous to African society. An early constitution like Nigerian Constitution of 1960 or its Republican Constitution of 1963 actually indicate that they give care or they care about privacy. Either way, one thing is very clear. Western influence, especially the Brussels effect, have effect on development of privacy, especially in the last 10 years. What kind of approaches, what kind of frameworks do we have in Africa? I divided them into three different approaches, or frameworks, or approaches. The first one is the African Union, which is kind of the equivalent of EU, a continental body of 55 African countries. They have the African Union Convention on Cybersecurity and Personal Data Protection, 2014, popularly called Malabo Convention. It's kind of a treaty, but the way the AU is not it's not as advocated the same organization method like EU. So it took almost 9 years before the treaty came to enforce in 2023. And some other regional economies, for example, the ECOWAS, Economic Community of West African States, have their own supplemental act on personal data protection as far back as 2010. This comprises of countries on the west coast, West Africa towards the Atlantic. It's kind of a binding treaty. It's binding on all the members' countries. The South African Development Community and also the East African Community, they kind of have a model law, which kind of a model law like a strategy where they can imbibe in forming their data protection law. These ones are not binding. Now go to the main big fish in the area, the country's personal laws. About 44 countries in December have their laws. This is kind of the map of this country that have data protection laws, and about 11 countries don't have the personal protection laws, even though I need to highlight that some of them currently have a bill pending before their legislative houses. Okay, for my research, we try to look at 10 laws in 20 different countries, covering a lot of 5 sub-regions in Africa. It was carried out by 3 independent researchers using thematic analysis after developing a code book. And we can have a high reliability when we check our CAPA reliability. Okay, in our code book, we look out, what we look out for in our research is who is the data protection laws applicable to government and industry, the public and the private sector. Does they have an extraterritorial reach like the GDPR? Who enforces data protection laws like DPA, just like the EU specify for a particular authority to regulate data protection law practices? Then we also look at for whether there is a mandatory data controller or processor registrations which require you to register with the DPA before registering or processing personal data. And kind of another thing that we observe is whether there is a periodic audit. Some of this country requires data controller to file annually kind of a periodic audit about how you manage their data, and kind of sanctions for violation of these laws, whether it's administrative, whether it's financial, whether it's civil, or whether it's criminal. Okay, our major result is that in all the 20 countries we sampled, all this country requires that their data protection laws is applicable to both their government and industry, that is the public and private sector, even though there's some kind of exceptions as in those laws stipulates. 50% of the country requires that periodic audits, for example, in case of Nigeria, by 21st of every year, data controllers or processors are required to find an audit with their DPA to ensure that they are complying with their laws and practices. This one particularly needs to be more paid attention to because there will be a lot of violation when people don't know aware of this practice that you have to comply or you have to file a periodic audit at a particular period of time. 55% of the 20 sample countries also kind of have an extraterritorial reach like the GDPR, which makes these laws applicable outside their offshore, where you are processing their persistence data. DPA, we noticed that in all those 20 African countries, of course, a governmental agency is responsible for enforcing data protection law. Unlike the US, where maybe the FTC or in some case of some states, the AG has a role to roll this function. It's mostly a government agency. While we noticed that some created new agencies like South Africa, Nigeria, Kenya, they created a new agency to regulate data protection. Some use an existing, like Rwanda and Zimbabwe, use an existing government department to regulate data protection. For data controller, we also observed that all these countries requires a data controllers or processor to register with them or notify them before processing their data. But one unique difference between these countries is some require you to register with them before processing, while some countries, in case of Nigeria, Somalia, and Malawi, for example, they require you to register when you're a significant controller, and you must register within 6 months of collection and processing data. For sanction, we noticed that administrative kind of 85% of the sample country have kind of a form of administrative sanctions, which requires the DPA can issue notice of violations, decision penalty. We observe that all the countries have a financial kind of a money sanction, fine, which can have monetary value or kind of a criminalized violation of data protection laws. That is, it can go to court, imprisonment, forfeiture can happen. And about 65 of these countries also have a private right of action, just like the GDPR and I think the GDPR. So, implication for privacy engineers. One thing we try to identify, we try to come up with is why privacy engineers are trying to look at this with data from this country. They can set up a compliance as a code in trying to deal with these laws. This makes streamline country-specific requirements directly in their development pipeline. Kind of have a dynamic consent where you're dealing with people from different countries, especially from this country, to manage this multi-country registration bottleneck and to map data not only by location but by jurisdiction and residency. Challenges, we have to admit it, the administration bottleneck of data registering with data controller can be an administrative challenge for a lot of privacy professionals. And of course, there are a lot of privacy engineers shortage on the continent, which affects enforcement generally. And also, there is a fear of governments, especially that we can see the trend of military coup in some countries in Africa and the misuse of some of these laws. And criminal sanctions, they can take in the form of a personal liability to officers, to alter egos, to directors of the companies, as the case may be. Opportunities. There's a growing demand for privacy engineers, experts in this field that have knowledge of some of those laws. Early compliance to some of these laws will build trust on the continent. Participation also in policy formulation, especially since some countries are already trying to amend their laws. Recommendations, we believe that privacy engineers can tap into the potential of even training more people in Africa, being a trainer like me, getting a paid trainer to train experts in this region, respecting African sovereignty. The issue of sovereignty has been a germane issue in data protection practices, especially from the global majority, that is global south, and a lot of countries are coming up with areas or ways in which they want people to respect their data privacy. For future research, we can also investigate the involving role of privacy engineers in enforcement of data protection laws in Africa. Thank you. This paper is an adaptation of this presentation is an adaptation of this paper, assessment of an enforcement mechanism in African data protection laws. Thank you.